I am Erica Wadlington with the DC Chamber of Commerce. I am the Director of Public Policy and Programs. Before I introduce our moderator and our President and CEO, Mr. Vincent Orange, I would like to give you a little bit background about the DC Chamber, and I'll play a short clip.
Washington, D.C., where the D.C. Chamber of Commerce is committed to supporting the business community by advocating, educating, and connecting in the nation's capital. Do you hear it? Do you feel it? Do you see it? Can you live it? Can you own it? Can you be it? At D.C. Chamber of Commerce, we live it, we own it, we believe it. We are the nation's voice of business, the voice of growth, your voice, the voice. We advocate, we connect, we educate. Our history is long and rich. In 1938, we started from the bottom as the Washington Chamber of Commerce. In 1946, we became the Negro Chamber of Commerce. In 1956, we became the District of Columbia Chamber of Commerce. And to this day and beyond, this is where our members stand, prosper, and grow. Today, Washington, D.C. is not just the capital city. We are the people's city. We are a vibrant city. We are a global city. We are the city of opportunity. The Chamber shall work to create a vibrant and thriving district economy that improves the quality of life for all. Please join us. Be a part of the change. We are open for business.
And without further ado, I would like to introduce our President and CEO, Mr. Vincent Orange.
All right, so let's give Erica a round of applause. She's been working extremely hard, and you can tell the entire staff has been working really hard to invite you to our new headquarters here at 1133 21st Street, and we're so elated to be here and really, really honored to have you be here as part of our first major event at this particular site. As she indicated, my name is Vincent Orange. I am the President and CEO of the DC Chamber of Commerce, and I'm happy to say that I made it through 1 year. So August 15th was my 1 year anniversary, so we are off and running. And today we're pleased to be here for this very important dialogue. The dialogue is on the Home Rule Act, Commuter tax, and the universal paid leave legislation that's been enacted. Now, as you know, we are here in a very unique position here in the nation's capital. Unlike the other states, we have these restrictions. So we thought we'd bring out the experts to talk about the Home Rule Act, the commuter tax, as well as the universal paid leave. And we think all these can come together, and these three individuals that we've invited here today can give us the insight that we need. They will talk about the limitations that are on the council, the fact that we can't tax at source. Then we have Walter Smith, who, you know, we say Eleanor Holmes Norton is our champion on the Hill, or Mr. Smith is our champion in the court system. He gets it done. And then we have our council member, as well as a constitutional expert, Mary Che is here with us as well. So we have these individuals here, and once I get to these notes, we will have them come up and we will commence. First, we'll have Attorney General Carl Racine please come up. He is the first elected Attorney General of the District of Columbia. Attorney General Racine has a broad and deep legal experience with a career that includes working in the D.C. Public Defender Service, serving as Associate White House Counsel in the first Clinton administration, to being the first African-American managing partner of a top 100 U.S. law firm, Venable. Welcome, Attorney General Carl Racine.
Thank you.
Next, we will have Councilmember Mary Che. She has served on the D.C. Council since 2007, and she is the chair of the Committee on Transportation and the Environment. Councilmember Che is also an attorney and a tenured constitutional law professor at George Washington University Law School. And, you know, they always say where there's a will, there's a way. And we know through Walter Smith, he has the will, and we believe that Mary Che has found the way around the Home Rule Act and could possibly get this legislation passed. So let's welcome Councilmember Mary Che. And next, I would like to bring up Attorney Walter Smith. He has been the executive director of the D.C. Appleseed since 2001. Previously, he served as the Special Deputy Corporation Counsel at the D.C. Office of the Corporation Counsel, now the Office of the Attorney General. He has practiced law 16 years at Hogan Lovells, where he also served as a partner and director of the firm's pro bono practice for several years. Relevant for today's discussion, Walter has argued numerous cases before the United States Supreme Court, the U.S. Court of Appeals, for the D.C. Circuit and Court of Appeals. Welcome, Mr. Smith. Thank you all for joining us today. So to get this started, we're going to have them give us a brief opening remarks, and we'll start with our Attorney General, Carl Racine.
Thank you, Mr. Chairman. We're going to make a revision to your planned schedule right away. We got together, as you said. Erica Wadlington has done a tremendous job of not only rallying the panelists here, but also getting you all to come back down from Martha's Vineyard. I'm happy to go back up if somebody's going up tomorrow. But the way that we decided to organize this, Council Member Shea would go first and talk about the legislation at issue. I would give some brief remarks related to the home rule structure and the prohibition, if you will, against commuter tax. And then Walter would really take the lead in talking about a way forward that Walter believes, and I'm happy to say that the Office of Attorney General also believes is a route for additional funding source that is not violative of the prohibition against commuter tax.
Okay, so we put our own stamp on this, so I'm first. I handed out to everybody, because, you know, being a law professor, you have to have handouts. You know, a little synopsis of each of the 5 bills that's currently in front of the council, and on which, as already has been mentioned, Chairman Mendelson will have a hearing on October 10th. Now, the focus of today really is on this Universal Paid Leave Act of 2016 that we passed. And as you may remember, it provides for medical leave, 2 weeks of medical leave, 6 weeks of family leave, 8 weeks of parental leave, though you can't take more than 8 weeks in a one-year period, but this is paid. This is all paid. And there are a variety of features about it, and you know, without getting into the weeds, the principal point about the bill, though, and I think points of contention, and why we're still looking at it, is that even though there is majority support for paid leave for employees in the District of Columbia, who work in the District of Columbia, there are a number of issues. One is, how much is it going to cost in a bureaucracy to set this whole thing up? We've already allocated $40 million to do that, and then there'll be costs after that in administration and enforcement. So it's a big bureaucracy. It's going to require continued money to keep it going, and that's one aspect, both the size of the bureaucracy and the cost. The second aspect is, who bears the bulk of the costs once we get underway? And the current bill provides for payment by the employer. And the amount of the payment is 0.62% of payroll to fund the program. So the question is there some better way to allocate costs and some better way to reduce the costs on our businesses? And in addition to the aspect of the cost to the government, aspect of the cost to the employers, then there's the question of equity. The way we have this system operating is that all employees who work in the District of Columbia will be able to avail themselves of the benefits of the bill, even though, and I see numbers vary, but about 2/3 of the employees who work in the district don't live in the district. So you'll have employees who pay nothing and yet get a rather significant benefit just because they work here. Now, the bills that you have in front of you, the little pieces that you have in front of you, identify some variations as we go through this. One aspect is to simply put a mandate on businesses of a certain size with a certain number of employees, in part because those larger businesses tend to provide benefits that almost mirror what we're seeking to apply across the board. And so you put a mandate on them, and they do that. And then the smaller businesses, hoping that perhaps maybe there can be insurance or a pool of insurance, would have to pay some amount of money, which could be subsidized by the larger businesses to some much smaller extent. That's a general kind of an approach. And by the way, you have some numbers here. Not all of these numbers are guaranteed. There's a lot of numbers flying around, but it's to give you some scale, I guess. And then, and by the way, I have signed on or put in bills myself, which are themselves contradictory. But I want to tell you the reason for that. The reason for that is we have to have the options in front of us. And the chairman, when it came time to see if the mayor was going to veto the bill as we passed it or not, I wanted to know from him, in terms of my own vote, about whether to sustain that veto if it came, but it didn't. I wanted to know from him, are you willing to consider these alternatives? Because I'm in support of this, but not in support necessarily of how we go about it. And he said yes, and true to his word, we're going to have a hearing on all of these bills. Again, a key feature in many of the bills is the mandate on the larger employees. Then there's, some restriction in some of the benefits in some of the bills. And then the most interesting aspect, which I can credit Walter Smith with, and that ultimately convinced me to put in this additional bill, is the one that treats what was regarded as a tax on employers to pay for all of this, instead as a fee. Why go through that trouble? Well, because if it's a fee, then it can be applied to the employees, resident and non-resident, because the Home Rule Act does not allow us to tax people who work here but don't live here. But we can charge fees. And Walter's going to talk about how we can walk that line between tax and fee. One of the reasons why the bill is as it is right now, and there's no charge to the employees, it was the idea that, well, we can't tax the non-resident employees, so it would be unfair to impose a burden on the people who live here and work here and not have any obligation on the other side. So that, I think, is a really promising, and we can talk obviously more about it, really promising avenue to travel. If we were to do that, then it would substantially lessen the amount that the businesses have to pay. It would be like Social Security. The employees pay something, the employers pay something. And in addition, swirling around all of this is a hope that there can be perhaps some insurance product. I see Wayne McGowan in the audience, and I'm going to out him. He's right over there. And he tells me that there may be some possibilities to have an insurance product, which would make this more palatable as well. Now, I would just focus also, and lastly, on the last bill, 22-334, which is the one that's been introduced by Chairman Mendelson. Now, Chairman Mendelson, as chairman, of course, has only one vote on the council, but there's a gravitational pull that typically goes with being the chairman and offering up a piece of legislation. And so his business would have the employer mandate for very large businesses, 100 or more employees, although they can opt into our district program. And then for the smaller businesses, there would be payment by the employers with some subsidy from the larger businesses, but then a payment by the smaller businesses that want to go in that direction. In any case, it would be less than what would be required to be paid by the employers under the current bill. So I would pay particular attention to that one, because who knows if that has some momentum behind it in particular. In any case, those are the options that we have. I think we will be earnestly trying to figure out the best way to do this, given that paid leave is something that I think enjoys wide support among the members of the council. And at that, I will, what did we decide?
Yep.
Yes, the Attorney General is next to talk about something or other.
Exactly. Thank you very much. Just two things to add, really, at the in the first instance. The Office of Attorney General doesn't vote on council legislation, so we don't have a voice, if you will, on the paid leave bill. I think you've captured the mood of the District of Columbia on the issue well, notwithstanding concerns, important concerns from the business community about cost. The second point I wanted to clarify with you, council member, is that the other states that have gone with the paid leave do in fact have a blended funding scheme with monies coming from the employer and the employees. So what is being proffered now or discussed and pushed now is entirely consistent with the 4 or 5 other states who are leading in this way. So with that, my job is really brief, and that is to essentially make the point that Congress has precluded us. Aren't you sick and tired of hearing that? What we can't do, right? I know Senator Brown is here, and he's working hard on those autonomy and statehood issues every day. But the long and short of it is this. When it comes to the powers that the District of Columbia has, Congress has given us certain powers and certain home rule, sort of autonomy. Of course, we have a wonderful council that the residents here vote for. We also have a mayor who the residents vote for, and then more recently, of course, folks started voting for another office, the Office of Attorney General. Congress restricted us specifically from doing many, many things, including, importantly, not having the ability to tax non-DC residents on income matters here. That obviously has been written about and spoken about at length. It's kind of a structural problem with our economic structure here in the District of Columbia. And while we can't argue fairness per se, it's certainly not fair. But that's the law. And so that brings us to then how can we consider an alternative that would in fact include taxing non-DC resident employees who work in the district. And Councilmember Shea hit it right on the head. All of this turns on whether or not the vehicle, the structure for funding, is deemed to be either a tax or a fee. A tax on non-DC residents is illegal. A fee is not. And there are certain hallmarks that make a vehicle a fee versus a tax. And while I can certainly go into that, I think I should pass that on over to Walter, who's done, I think, excellent analysis. I can tell you again that the Office of Attorney General reviewed Walter's analysis, and we entirely agree with it. We don't think that that we would run afoul of the tax prohibition.
Is that me now?
That's you, bro.
Okay, so hi everyone. I'm glad to be here today to talk about this issue. I actually go way back with Mr. Orange on this issue. I remember the morning we had a press conference in front of the courthouse the day we filed a lawsuit challenging the constitutionality of what Alice Riven likes to call a non-resident income tax ban, not a commuter tax ban. We didn't win that lawsuit, but it helped us to bring visibility to one more piece of our lack of democracy. And you may not know this, but it was now Supreme Court Justice John Roberts who wrote the opinion against us on that issue, which only emboldened a number of us to begin to think about other ways to advance democracy here in the city. And sometimes you can't do that without being pretty aggressive and without being prepared to be quite adversarial. Chairman Mendelson has had to live through two of these that we recently lived through. One of them was the idea that we had the authority under the Home Rule Act to amend local law to give ourselves an elected attorney general, the product of which is sitting right over there. That resulted in a lawsuit in order to vindicate our right to do that. Another example was the effort to bring the city budget autonomy, again using the provisions of the Home Rule Act to get there. We're not 100% there yet, but we're further than we were before. And that too caused us to have to go through a lawsuit in order to try to vindicate that view. This issue may be another example of that. Under the Home Rule Act, as Carl Racine points out, the District of Columbia is singled out as the only jurisdiction in the country where Congress has prohibited that jurisdiction from having a non-resident income tax. I'm sure you know this, but 43 states in this country have an income tax. Every single one of them has a non-resident income tax. And the reason they do is they want to ask people who work in that jurisdiction to pay their fair share of the cost of providing services to people who work there. We cannot do that, which drives us to think about the issue that's in front of us today. Is there an argument that the paid leave bill could be structured in such a way that non-residents could be asked to pay their fair share of the cost of paid leave consistent with the prohibition in the Home Rule Act? I think the answer is yes. Not a slam dunk, but it is another tool, as Mary Chase said, that the council ought to know it has available to it as it rethinks the bill. You probably know this, that in the committee print that gives us the legislative history of the current version of the paid leave bill, it was quite clear that the council did not even consider the possibility of sharing costs between employers and employees because the council thought it could not do so. Now that doesn't mean that even if it had that tool available, it should do that. We just want people to know that you may have that option available and for council members to know that going forward. Now, why do I think that's arguable? Last year, the U.S. Court of Appeals for the District of Columbia Circuit handed down a decision, I think it was in March or so. This is a case in which the Attorney General's office was involved, where the question of how do you differentiate between a fee and a tax came up. And as Carl said, the key here, if the council wants to impose a charge on non-residents, it's going to have to be because the charge can be characterized as a fee, not a tax. So the question legally of what is the difference between the two becomes critical. In the D.C. Circuit's decision, they laid out the criteria for determining the difference, and under that decision, it's pretty clear that the court thought that a charge is a fee if what you're asking people to do is pay their fair share, roughly, of benefits to be received. Whereas a tax is a charge imposed on a general population across the board as to which you may or may not receive benefits in return. The question would be, if the council wants to use this possibility, is on which side would this fall if in fact the council wanted to set this up as a fee? I think a very good argument could be made that if you ask people to pay their fair share of the cost of paid leave benefits, measured in part by what their own income level is, and that point will be made against us if someone wanted to challenge it, but the reason you have to measure it by their own income is they're going to receive benefits measured by their own income. So I think this is worth considering, but only if this is something the council wants to do otherwise. We're not arguing this should be done because you could do it, or because it advances democracy. We just want the council to know that this is a viable tool available. I do think that if the council goes this direction, there is some risk of a lawsuit. Although not necessarily so, because non-residents are going to be receiving something in exchange for what they're being asked to pay. But everyone would rather have something for free than pay for it. And right now, under the current version of the paid leave bill, non-residents are going to receive paid leave benefits without paying anything. So this will be the issue going forward. How to think about this tool, how to think about, for those who are risk averse, whether or not if this tool is employed, how much risk is there of a lawsuit being brought, and if one is brought, what is the likelihood of winning it. My view about that is that if we're going to continue to claim that the District of Columbia ought to have the same prerogatives, the same rights as other jurisdictions, sometimes you're going to have to run the risk of a lawsuit. And because I think we would likely win it if it were brought, it's a reason to consider the tool seriously. There's one other reason why I think we're more likely than not to win a lawsuit if one is brought. And that is, if a suit is brought, it has to be brought in the local courts. It has to be brought in the D.C. Superior Court under a provision that says anytime someone wants to challenge what they call a tax, they cannot bring that in the federal district court. So unlike in some of the other cases where a suit is brought and then the other side removes it to the federal district court because they think they have a better chance of winning it than in the local courts, that wouldn't happen here. But nevertheless, it's a risk, it's an element to weigh, and I think it's worthwhile for the council to know if it's going to rethink this bill that this may be an available option. So, and a shout out to Margaret Singleton back there, who knows about all of this. She sat on our board for quite some time, and we're happy to be working with her and Mr. Orange on this issue.
Okay, well, thank you all very much for your introduction. So just to make sure we're all on the same page, today the law of the land is D.C. Law 21-264, the Universal Paid Leave Amendment Act, and it calls for a district-run paid leave program for individuals in the District of Columbia. We're here today. We're not arguing the benefits. Everybody is clear that it appears that everyone wants to provide 8 weeks of parental leave, 6 weeks of family leave, and 2 weeks of medical leave. And the bills that are before us, except for Bill 22-302, is really talking about a different funding mechanism, but it keeps everything else intact. Bill 22-302 would repeal the current law and go in a different direction. Now, Councilmember Che, under your bill, it's more in line with cost sharing. Cost sharing is utilized in California, New York, and New Jersey. Wouldn't this be the opportune time for us to move forward in light of the American Council of Life Insurers versus DC Health Benefit Exchange, where that case really stands for if it can be a fee if you're paying for a direct benefit. And it's clear that the individuals that will receive 8, 6, or 2 are getting a clear direct benefit.
I think that this is a wonderful approach. I don't think we're doing a frontal assault on the Home Rule Act. No. All we're trying to do is fit ourselves within the terms of the Home Rule Act. And I think that prior case and also some prior experience here in the District of Columbia when the District of Columbia wanted to impose a fee, a water fee, sustainability fee, right, on the federal government, which is not subject to taxation by the locality. They resisted. They said, you can't tax us. We said, it's not a tax, it's a fee. And it didn't go to court, but they ultimately accepted our view. And the linchpin of this is, again, this idea, if there's a defined group of beneficiaries and payment in accordance with your receiving those benefits, that's a fee. It's not a general tax. It's not to pay for the operations of the government or anything like that. So I think our maybe I'm too optimistic, but I think with Walter Smith and Carl Racine, slam dunk. No. I think we have a very, very good shot at it. And I think that it would enable us to respond to one of the serious objections I know that the mayor had. She said it's inequitable to think about this without thinking about, the overwhelming number of beneficiaries who don't even live here that would get this benefit. And it does comport, as the Attorney General has noted, with how other states do this. And let me just add, because other folks might want to say something about this, but the reason why we have this interim period, in order to be able to fix things, make them better from my perspective, is that the mayor is to start getting the contributions from employers by July 1, 2019, okay? And benefits for employees are to begin July 1, 2020. Even though the money is there to stand up an electronic program, to get things underway, and we've already put that money in there, the actual operations don't begin until a time forward that will give us a chance, if we can all agree on something, to, I think, fix this bill up, get what we want at the end of the day substantively, but to do it in a way that's more palatable.
Now, Attorney Walter Smith, as well as our Attorney General Carl Racine, and Carl, I saw your name on the court case, the U.S. Court of Appeals American Council of Life Insurers versus the D.C. Health Benefit Exchange. And it's interesting that this case was argued in January of 2016 and decided very quickly in March of 2016. And the both of you have mentioned what I believe is the test in the case, where it says the hallmark of a fee. And could you guys elaborate upon the hallmark of a fee? In particular, it says here, the hallmark of a fee is at least a rough match between the sum paid and the broadly defined benefit provided. And clearly, under the current law, where there's a $250 million tax imposed, about 165 million of those dollars goes to non-residents. And there clearly is a mismatch. And if I am a DC resident working in Maryland, I cannot get the benefit. So can you talk about the hallmark of a fee as it relates to this case, and why, if you do believe so, that we will be on solid footing arguing the hallmark of the fee?
Well, we have looked to see if there's been any case law to come down since this decision, and there hasn't been. So if there were a suit, or even if there weren't a suit, the people advising the district on this legislation, I think, are going to be looking to this case to decide whether or not it is legally permissible to structure this as a fee. And you've already read what is the key. It's hard to expand much further. There are other things discussed in the decision, but I think you're right in saying what the hallmark is. Either you have a charge that is for general revenue purposes, which everyone has to pay, whether or not you get any rough return as a measured benefit, that's a tax. Or on the other hand, it's a fee if there's a limited class of people, all of who are asked to pay into a pool, and they get roughly something back in proportion to what they paid in. That is essentially the way the whole paid leave program is already structured. So in some ways, Mr. Orange, what the council's already done is tailor-made, I think, to meet the hallmark test as set out in the court's decision. And I would expect us, especially if we're in the D.C. Superior Court or the D.C. Court of Appeals, to prevail. But I don't think it's a slam dunk. But I certainly think not only the words of the test, but also the equities. I think the equities of the situation may influence the court, because otherwise we're going to be in the sort of anomalous situation where the district is required to set up a program from which I don't think they could constitutionally exclude non-residents for a different reason. They're required to include the non-residents, but the district is precluded from setting this up in such a way to ask them to pay their fair share of the benefits to be received. And I think that situation will be persuasive to a court if we come
So
to
the
that.
hallmark of whether a fee or a tax has been well described by everyone, and there's that real sort of nexus of proportionality, right? Where the employees, in this case, if we were to go forward with the proposed Smith approach, would be paying something that is related to the very benefit that they'd be receiving. So that hallmark part is really important. There are a couple of other factors that courts have used in considering the question of whether a scheme is a tax or a fee, and I think it's probably worth our while just touching on those. The first factor is who's the body that's imposing this assessment. Generally speaking, when legislatures propose assessments, those tend to be more like taxes. And so if the council were in fact to impose this employee assessment, we would have to get through that factor, which on its own would militate in favor of a finding that that's a tax. The second factor that courts consider is they want to know the breadth of the population on which the charge falls. As we know from taxes, generally speaking, if the breadth of the population is everybody, then that's a kind of a classic tax. If it's more specific or narrowed, it seems to move away from a tax to a penalty or a fee. And so that factor would, I think, go into the checkbox for this scheme being viewed as a fee. The last piece of this is, do we have a fund that is actually going to maintain the monies going in and out? If we don't, and instead the monies that we collect through these fees, we call them, go into the general fund, then that would be a factor for a court to say, hey, this looks like a tax. It's going in with all the other taxes. So I do think that there has to be some planning and some strategy around how we formulate, if we go forward with the scheme, this approach, to make sure that we've got all of our best arguments in order, knowing where the other side, and I'm sure there will be a plaintiff, knowing that we had not given them other arguments that we needn't have given them.
Well, Councilmember Che, I'm going to come to you. So looking at your bill 22-325, it would require covered employees to pay a fee of 0.42% of his or her wages into the Universal Paid Leave Implementation Fund, and the employer would pay a tax of 0.2% of its employees' wages. Now, in the American Council case, it says the key question, whether a charge raises revenue merely to cover the cost of offering a service to the payers of the fee. Do you believe that your cost in your case is merely paying for the benefit that one would receive?
There has to be some infrastructure to allow this to work. So, but primarily, if you look at the, we had a fiscal impact statement of the original bill, and the bulk of the money, the absolute bulk of the money, is in benefits. But there has to be, after the proposal is, the infrastructure is created, going forward, the money that's raised from at the current law, the employer tax, the vast bulk of it is for benefits. So I don't think we have a problem there, but I do want to respond to something that the Attorney General said. Yes, we're going to have to be very, very careful, and I'll just share with you something that I found amusing. When I was taking the bill that we had and sort of recrafting it as a fee instead of a tax, and I was proofreading what was in there, although legislative intent is not going to carry the day, it would look bad if we, on some occasion in the bill, referred to it as a tax instead of a fee. And I found occasions where I said, well, no, I could cross that out. So from even that minor perspective, we don't want to make any mistakes. We want to craft it, as best we can. And I think we can do that. You're right, Carl. There's at least one anomalous aspect to this. It's coming from the legislature, and we tend to impose taxes, but we intend to impose fees, too. So it's not really, I don't think that's...
What did the other
terribly-
states do? Did it come from their legislators, or was it a product of an initiative?
Well, I think it was legislative, although the particulars were then relegated to, rulemaking.
I got you.
But I don't know how problematic that is. But I also want to follow up on something that Walter said earlier, just in case there was any question about that, because I find this fascinating, and I never get to talk about the Privileges and Immunities Clause in public. So I'm going to take an opportunity to do that. Walter said quite correctly that we could not have said, look, we're going to have this program, and the out-of-state residents who work here, they can't share in it. The reason why we can't do that, we can reserve benefits that the government gives to the, something the government pays for, but this is a program where we're charging private entities, and then we're telling them that they would have to discriminate against non-residents. There is a provision in the Constitution, the Privileges and Immunities Clause, that does not permit that. So it came up in some of the discussions, well, why don't we leave them out? Well, we can't. We can't leave them out. So I just want you to understand that there is a solid reason for that, even if we wanted to be selfish and just apply it to the residents who work here and not to the residents who don't live here. I mean, not to the workers who don't live here. We're prohibited from doing that. So I know that's a little sidelight, but I wanted to explain that. And as I said, I get few opportunities to invoke that clause.
Can I just say, though, that to me, that underscores the equitable point I was trying to make a minute ago, that if you want to have a paid leave program for people who work in the district, the Privileges and Immunities Clause will not let you exclude non-residents from the program, but at the same time, if we're not allowed to structure this as a fee, you end up being required also to let them participate for free, or in other words, without paying their fair share of the costs. And just one other follow-up, Mr. Orange, I think the language of the decision, though, does not preclude the possibility that some of the funds that are part of the fee would be used to fund the regulatory structure.
Right.
I think the key sentence in the opinion is, we believe that in practice, the key question is whether a charge raises revenue merely to cover the cost of offering services to the payers of the fee, including financing regulatory systems applicable to them, or whether it also raises revenue for purposes that aren't especially beneficial or useful to the payers. And the reason why this particular case was held to be a tax, as the opinion pointed out, was that the American Council of Life Insurance, who brought the suit, said, wait a minute, we're being asked to pay a fee to help pay for the DC Health Exchange with regard to products that are not even on the exchange. So that was called a tax because they were receiving nothing in exchange for what they were paying. Unlike the case here, where everyone who's being asked to pay a fee or a charge would at the same time be entitled also in some rough proportion to receive a benefit in exchange.
Don't you see the outlines of the brief already?
I just saw an op-ed, actually.
Yeah, absolutely. Walter, I wanted to ask you, this is a real technical point, but you made this point a little earlier, and you're kind of alluding to it right now. In the lower courts, both parties argued that it was, in fact, a fee. But then when they got to the Court of Appeals, they argued that it was a tax and that the court had no jurisdiction. Only the Superior Court Tax Division could actually hear this case. Right. Now, do you think that is a benefit for the District of Columbia going forward, if we were to go forward with something like this, that it would be heard at the D.C. Superior Court Tax Division?
Well, I think, I think we are better off being in our own local court here. Partly because there are a lot of decisions that say, in the end, you want to give deference to the local court with regard to the construction of its own local statute. And I think a whole lot of deference ought to be given to the D.C. Court of Appeals' view of the meaning of the prohibition in the Home Rule Act with regard to a non-resident income tax. And that's why I think this case, if there is such a case, and I'm not certain there will be one, but if there is one, I think it belongs in the local courts.
Yeah,
And then
I
Councilmember-
totally agree with that, and just my experience is that the judges, both on Superior Court and certainly the D.C. Court of Appeals, really see it as their special obligation to not only follow law, of course, but to really be the voice, the definitive voice, if you will, on matters of D.C. law. And they candidly, get upset when offices, perhaps even like mine, remove matters that concern statehood, autonomy, away from the local court and into the federal court. Here, we'd be very confident that we'd be in the right court in Superior Court and the DCCA, and I do think that home field, if you will, advantage would be quite beneficial.
Councilmember Che, the second part of the key question in the case, and going directly back to what you have proposed, it also states whether the charge also raises revenue for purposes that aren't especially beneficial or useful to payers or required for pursuit of their business. In this particular case, would you say that your tax only raises revenue to provide the 862, and incidentally, obviously you have to set up the administration and get the system up and running, but other than that, it doesn't utilize those funds beyond those benefits?
No, and you called it a tax. It's a fee now.
Get the lingo right now.
Yeah, exactly.
It's a fee.
But you're right, and that's a nice softball question, because I think it can be set up, and we can think about every aspect of this from the ultimate outcome if it went to court. What would be most likely to get us the right ruling, and that would be one of them. Sometimes we do create special purpose funds, but then in a succeeding budget, sometimes the executive branch raids those for other purposes, and we make a big hue and cry about it. But I would be especially careful in trying to insulate any raid on that money for any other purposes, because it would defeat our objective.
Now the hard question.
Oh, no, I take part.
Chairman Mendelson's bill, 22-334.
Yes.
Basically, it allows employers with more than 100 employees to pretty much provide for the family, medical, and parental leave to its employees, and then they would have to pay 0.15%, and they can basically go about their own way. Any employers that have 100 employees or less will be required to pay the 0.54% unless they are already providing those benefits. And so at the end of the day, I guess the question is Bill 22-325 versus Bill 22-334. From a business point of view, which bill is cheaper in terms of dollars coming out of the business person's pocket?
Well, I think that it's better, equitably, and financially, that we get the beneficiaries to share the cost and to have that as broad a base as possible, namely residents and non-residents. That being said, and then the employer paying the other share, it seems to me that it's, if I were in the business community, I would want to see that implemented. Now, we can also play with some of the benefits and the timing and things of that sort, but assuming it stays relatively the same, I think that the employee, as in, again, the case of Social Security or something like that, the employee should have an investment in these benefits. And the employee would have an investment, and I think that the cost would come down because of that broader base of sharing.
So I would ask Attorney Smith and Attorney General, in terms of the District of Columbia's fight for statehood, and clearly, Walter, you've written a number of articles on the fact that we've lost billions of dollars because we cannot tax at source, we cannot tax federal properties, and this continues to go on and on and on and on. Would this be a missed opportunity if we did not go down this path and try to go with Bill 22-325 when it appears to be pretty much on all fours with the American Council case? And let me say one other thing. Under the three-pronged test of the American Council's case, the first prong that Attorney General, that you were talking about, the court seems to kind of dismiss that particular factor.
I don't think it's as important a factor as the hallmark,
the other two,
which is, hey,
but would this be a missed
is the money
opportunity?
going to the folks? Is there a benefit going to the folks who are paying the fee?
Would this be a missed opportunity? I mean, the way this case, the way it's set up, and clearly we can show that of the $250 million tax that's currently in place to start later in the future, that 160 million plus will go to non-residents. And clearly we can show the distinction that in this case, it'll be more aligned with the actual benefit that's being produced. And why would we want to, have the business community or anyone pay $250 million forever without going and taking this final step to see whether or not constitutionally that we can make this work, especially in light of the fact that the Office of Attorney General has already argued the case and won the case.
Well,
This particular American Council case.
sure, yeah. I'm not going to answer your leading question.
Objection.
Exactly. No, but I would just say that, I think that this possibility, really, really brings new opportunities for thought about reliable sourcing funds. Here, with the problem that the council is seeking to solve, there would seem to be, frankly, no more logical, commonsensically, no better legal approach than to proceed with the employee sharing piece of it. Now, it's on the council to figure out, how to balance the equities of which percentage is employee, which percentage is employer.
Can I just say, I think the missed opportunity would be not to at least consider this as a tool going forward. I don't think simply because you have a good argument to do it, you therefore necessarily should. And as Councilmember Che knows, some of her colleagues are not going to want to reopen the bill that's already been passed. And that bill, as you know, puts the entirety of the cost on employers. And there will be people arguing that that is the fairest, most equitable way to proceed. So I do think it ought to be considered, and I think it would be a missed opportunity not to realize that this is one way to proceed. But I don't think the council should do it simply because it's got an argument that it could. I think the merits need to be weighed, and I agree with Carl that there's more than one way to cost share this thing. If you start with the proposition that the cost is 0.62%, let's assume that's the right number, there are going to be different council members who have different views about how to split that 0.62. And there will be council members who will be concerned that there are certain low-income people who might not be able to afford even a 0.42 imposition, and I think that needs also to be considered. But it is a tool that's available, to go back to the words that Mary Che used earlier, and I think it ought to be seriously looked at. And if the council wants to do it, the council will need to get its ducks in a row. The statute will have to be thought through with this tool in mind. The legislative history will need to be carefully crafted to show that you understood the option and you have permissibly used it.
Well, we're going to move to the audience, but I do have one last question before we move to the audience for questions. But to sum this up, in looking at Councilmember Che's bill, clearly want to say that the fee is a trigger to a benefit, whereas in the case of the law that's passed now on the table, there's no trigger to a benefit. It's just the business community is going to pay this $250 million. We got to come up with up to another $80 million to set up the infrastructure. And then on an annual basis, we have to pay $18 million to fund almost 203 FTEs. While of this $160 million that's leaving the city, the other $90 million that remains, east of the river is only getting $12 million. I mean, how can that be equitable? And why would we not take the next step to at least say that we've dotted all the I's and crossed all the T's and we tried everything that we could to make it equitable?
Can I just say something, to this particular audience? If you come to the conclusion that this is a better way, it would be very important for you to communicate that as strongly as you can to members of the council. I don't think this is something where you can sit on the sidelines or wait and see what happens. This is a big deal, and to get this done, I would encourage you to put your force behind it. But these gentlemen don't have to say that, but I want to say that, okay?
Thank you. I'm Rick Rybeck with Just Economics, and back when I was a member of the council staff, I drafted a bill for Council Member Hilda Mason, the Clean Air Compliance Fee Act, which relied on the distinction between taxes and fees. So I'm very fond of what you're doing and agree with it. Just wanted to ask and make sure that the revenues that are raised, they don't go in the general fund, do they? They go into a segregated.
We'll have to have something that's separate and secure from rating.
Right.
I have a question about the jurisdictional issue relative to challenging the tax. And you mentioned that all challenges to taxes have, under the DC law, have to go to the tax division of DC Superior Court. My question is, what if someone raises a constitutional question about the fees/tax? Could they possibly get that removed to federal court?
I don't
No.
think so.
No, in fact, I believe if you look at the charter itself makes clear, and Congress gave us this, that questions related to the propriety of a DC tax go to the exclusive jurisdiction of the tax division in Superior
Can I
Court.
just have a follow-up question?
Sure.
But if the person is saying what we've done is inconsistent with Congress's authority under Article 1 of the Constitution,
Right?
they couldn't get that removed to federal. I'm just asking, they couldn't get that removed to federal court. You don't think they could get that removed?
I mean, I'm sure they would try, but, the other argument would be that, hey, Congress decided this a long time ago. It said that when you have questions about DC tax, don't go to federal court, go to the exclusive court, that's the Superior Court. So that would be.
I don't think you can circumvent
You can't.
the prohibition by trying to dress it up as a violation of Article 1, Section 8. I see that happen all the time, and I don't think the court will allow that.
How would you challenge a commuter tax if that's the case? How would you challenge a commuter tax if that is in fact the case?
I think we already have a built-in home rule court advantage here if they attempt to do that, because that will be the essence of the challenge. This is a prohibited commuter tax. And I think under the provision that this case cites, they won't be able to bring that other than in the local Superior Court. That will be debated. I guarantee you they will attempt to bring this in federal court. And if that happens, I think if the Attorney General is defending the suit, he will say to the federal district court, this doesn't lie here. You have no jurisdiction. It'll be an interesting technical debate to have.
Okay, this question may belie my naivete, but what about the challenge of the Virginia and Maryland delegations challenging this as part of the congressional review process? When the bill goes up to the Hill for congressional review and they say, we don't want our constituents to have to pay a fee, and then they kick it back.
That's not naivete, that's reality.
Yeah.
And whether that rears up is a good question because, at any time, because under Article 1, Congress is the full and plenary authority for the District of Columbia. They could say that the District of Columbia may not impose any fee in order to pay for, they could stop us in our tracks at any time if they chose to do so.
Hey, I just think that would be part of the getting all of our ducks in order. We would need, a lot of advocacy on the Hill from Congresswoman Norton and a bunch of others. We've seen litigants and parties, seek access to Congress to defeat lawsuits. Think about Care First, for example.
Right.
Went to Congress, and Maryland and Virginia were incredibly strong in essentially invalidating the concept that Care First would have to pay, reserves for a number of years, such that now we have only 1 year at issue. So there'd be a lot of ducks to line up, and we'd have to be all in it together on this one.
I'm not a lawyer, so my question is not a legal one. I am, however, a kid that grew up in Newark, New Jersey, so I know a lot about bullies, and Congress is a bully. And the problem that I have with this, besides giving 2/3 of the money to the people that live in Maryland and Virginia, is it weakens our position as we go up to the Hill. I've talked to Mr. Smith about this in the past. We always negotiate with the lowest common denominator. I'm not against doing this. I'm not against budget autonomy, but we don't put any force behind our effort for statehood, which is the thing that would resolve all these problems for us. And Jack Kemp, who was an advocate for the DC Voting Rights Act, said that he was an advocate for that act because he didn't want 2 Democratic senators. He was willing to give Eleanor Holmes Norton a vote because he didn't want 2 Democratic senators. Well, we don't put any effort behind our effort for statehood, and this weakens our position in everything we negotiate for, in my opinion, because we go in with the lowest common denominator. And just to frame that for you, we've spent $24,500 for each student in DC. We spent $300 for each man, woman, and child that lives in the district to build a streetcar line on 8th Street. But we spent $2, including the $984,000 the mayor just put in it for statehood. $2 a year for statehood. And I think this weakens our position across the board. So my question to my councilwoman is, why doesn't the council stand behind DC statehood?
The council does stand behind DC statehood. As you know, we attempted to move the Tennessee option, and we had the referendum and that sort of thing. But you raise a fundamental question, and I grapple with it all the time. In fact, I'm writing yet another article, we were on that panel together, about giving the delegate a vote, not in general, but over matters that are exclusively related to the district. And it's the question about, how does incrementalism cut?
Right.
And I'm particularly concerned about the incrementalism that gives a vote to the delegate, because what is the, as they say in the terminology, what are the optics? The optics are, you say, well, we don't have a vote. Well, now you have a vote. It might be a crappy vote. It might be like a nothing vote. But, when you do these things, there is an argument that you take away the intensity of the grievance, and thereby delay or maybe, sacrifice the ultimate objective, which should be statehood. And I understand that, but it's problematic. So what do we do in the meanwhile? What do we do in the meanwhile? We have a paid leave bill in front of us. So should we not take advantage of some opportunity to share the costs among all the beneficiaries? I get your point, and your point is, more particular about funding, I know. But the larger point is this business about incrementalism. Should you do it because you make some progress? Should you not do it because you make some progress and then deflect from the ultimate objective? It's tough. I grapple with it all the time.
But my point really is that we need to stop sitting in the middle of us.
Back to the legal questions. First of all, I want to thank all three of you because I think you've put forward an impressive and in many ways very persuasive presentation on this issue of the fee versus the tax. My question is one of timing legally. I think we all recognize that this would generate a challenge legally, and undoubtedly, if you prevailed in the Superior Court, an appeal. What would that appeal timeline look like? And for those who are the strongest proponents of existing law, the existing UPL law, one of the points they're going to make is that this is going to hold a cloud over whatever replaces it, the fee versus tax initiative. Number one, and number two, what are the prospects of prevailing against a move to enjoin the law and not enforce it during that period?
Well, one of the things that is beneficial here, and I'll leave the more technical timing to the Attorney General, is, as I mentioned, and I'm looking again for the dates, but under the current bill, it would not begin to collect the money from employers until July 2019 and not pay out benefits until, I think it's July 2020. You know, there's time. I think there's time. Maybe you can talk about timelines.
Yeah, as far as timelines for a lawsuit, I think the questions here are all legal, and they don't necessarily entail a lot of factual discovery. So that would slow, or should I say, expedite the normal process of a case. We can never, ever give any kind of reasonable estimate. I would say that the Superior Court matter would take at minimum 6 months, maximum 18 months, more likely somewhere between 6 and 10. And then the DC Court of Appeals, again, focused on a question of law, a pure question of law, would take less than normal appellate cases, but still, you could see somebody persuasively argue that legal delays could cause 2.5 years of time to pass.
I think the key would be whether or not someone bringing a suit could get a stay, could get preliminary injunctive relief. And the burden of proof would be on them, as you know, to show likelihood of success, irreparable injury, and all of the rest. And again, I think the odds would be on our side with regard to them getting that kind of showing made. And even if they got injunctive relief, then I think you would get expedited review in the DC Court of Appeals if they stayed the applicability of the statute. But Mary is right, given the timing already built into the statute, we have time to litigate this thing before the current bill would even be triggered.
Yeah. Under the 5 different variations presented, how is the word employee defined? Is that a full-time worker, somebody who has to work 40 hours, or are part-time employees covered?
There are some variations in that. I don't have all the particulars in front of me. In some cases, it's, working 24 hours a week, which is part-time essentially, but 24 hours a week. And in some cases, how long do you have to work before you can avail yourself of the benefits? Does it have to be a year, 6 months? There's a lot of variation in all the bills, but that could be up for evaluation as well. In other words, when we go back at this, I assume we're not going to go back at it, and which is one of the reasons why the people who support the current bill are anxious. I assume that when we go back at it, each of these features would be ones that would be open again to discussion.
This question is for the Attorney General. Have you in your office done a full review of Councilwoman Shea's legislation? If so, do you believe that it's legally sufficient?
We're not there yet.
Yeah, we're not there yet because I don't think the legislation itself has been fully fleshed out. But here's what we've done. We took a hard look at a submission that Walter provided to the council. We also went beyond that to contemplate what a lawsuit against such a scheme might look like. And we've concluded on that basis, not seeing the full-on legislation, that the fee structure is a legal structure that we could defend.
Hi, I had a question. I had questioned Councilmember Shea once before when I went into her office in terms of the bill. I do employee benefits, et cetera, and I just left a client who said, please tell me what we're going to do. Because they have short and long-term disability, and actually, in terms of waiting, I truly like the fee idea, and I also like the shared idea as well. And the implementation time, it takes that long to design benefits and do all of the other things that for employers. So I like the bill, I like the cost sharing, it's worked in the states that you're talking about. I like the fee structure. Are these benefits going to be taxable benefits when they're received? Because in short-term disability, there's a short-term disability policy if you purchase it yourself, because I could see a person say, I want to opt out because I don't want to pay that fee and I'm not going to get disabled. Is it my right to opt out of this fee?
Now, you said that you came in my office and asked me this question before. Did I have an answer?
Stick with it, yeah.
Because you want to stick with it, right?
But you didn't have this program design, which I do like.
Right. I'm at a loss to
Okay.
say.
Because I think we have to look at some of the existing programs that work in these companies.
Right.
The short-term disability for maternity, et cetera. Most of them don't, and small companies don't have family leave.
Right.
So again, when we look at this, just don't look at it just from the perspective of the legal perspective, et cetera, but look at it from the employer-employee perspective as well as the benefit perspective. And I think when we make those conclusions, again, the fee is a great idea. But let's also take into account what it takes to offer these benefits when they're already and currently offered.
You know, it would be very helpful to me and to the council if you could identify you had a number of questions built into that. She did that already, and send that to me again. Would you do that? Okay.
Is this bill, would it be something that could be subject to like a declaratory finding?
Declaratory judgment?
Judgment, yes.
That we would seek it ourselves?
Yes.
In anticipation?
No, I don't think that would be the appropriate posture. I think what we do is if we went with it, we would be prepared to defend it, period. Let the folks who are contesting it file the suit and have them have the burden of proof, as Walter outlined.
Right.
I do think, though, Carl is right, that if the council is going to proceed with this fee structure in the bill, I think it behooves council members and others to be talking to some of the elected officials from Virginia and Maryland and get Eleanor involved in this conversation. Don't blindside these people. Let them know what you're doing and why you think it's fair and equitable, because I do think that's how you're going to come out.
Exactly. Right, so I think you guys wore everybody out. I've never been involved in a dialogue with them. No more questions from the audience. Any closing thoughts?
No, I just want to thank the Chamber again for organizing this event, including the Office of Attorney General. It's always a pleasure to be with the council member and with Walter, and good to see you, Vincent.
My thanks, too. I think this is great, and it helps the council whenever people who are affected by our laws, that we hear from them, and they, give us some help. Whenever that happens, we're all benefited. So please do that.
And ditto.
Well, let's give them a round of applause. Thank you all so much for coming out.